Sorry, I just need to close this piece of software. Okay guys, let's start this. We're quite late. So yesterday when we ended, we were near that discussion of science, right?
Yes.
That's where we were ending. Okay, so is everyone clear about that?
Yes.
I think we can move on from there now. That I just have to go there because I missed it in the previous section, the discussion of science. So it's pretty important actually. I'm pretty sure this is not taught in any MBA program, but it's an important idea that you should have. Okay, so read this section once again. So remember falsifiability, and you can also see the connection between, you should also be able to see the connection, and that connection is actually highlighted also in this ebook. Okay, that there is a connection between a falsifiable statement, which is a scientific, the only truly scientific statement, and a positive statement. Can you see the connection? Usually positive statements are statements of fact, okay, that the temperature in this room is below 30 Celsius. Is that a scientific, is that a falsifiable statement?
Yes.
Yes, right? Because you can take the temperature and see whether the remark is false or correct. But if I say the temperature in this room is too cold, that's a normative statement actually, because I'm saying this is too cold. Some people might find it too, some people might find it too hot. Okay, so those kind of, you have to be careful. The reason this is important even in a business school, normally these things are taught in philosophy of science courses, this idea of Popper, etc. But the reason it's important in a business school is in the world of business, especially if you're in financial markets or even in other areas, you'll find very often that people are talking all kinds of, so-called experts are talking all kinds of, they're talking in very highfalutin language, but they're actually not making falsifiable statements. So in general, the statements which are not falsifiable are not that useful. Okay, because these are just global statements. I think the market will go up, or I think, the dollar will be quite strong. What's the meaning of that? I mean, quite strong. What do you mean by quite strong? Going up by 5%, 35%, 45%. So these are all vague statements. So a lot of these experts, like I've asked you guys to watch media, follow the news and business media and things like that. You'll find a lot of the experts you need to do that because you need to be aware of what's going on. But you'll notice also when you're looking at experts, you're listening to experts on TV, etc. Look out for this. Are they making statements when they purport to be talking about, the outlook for markets or the outlook for the economy? The kind of statements they are making, are they making falsifiable statements? Yeah. Are they making falsifiable statements, or are they making just global statements? Like, I think the dollar will be quite weak, or things like that, which is, these are very subjective statements. So watch out for that, because those kind of statements are not that useful. So if any of you go into, because one of the types of careers that you guys can consider is to go into business journalism. Okay, if you go with an MBA program, with an MBA background, you can go into business journalism. It's quite lucrative because the anchors get paid a lot. And if you're interested in that kind of work, so one of the things you have to look out for as a business anchor is to press, if you have a guest who's supposed to be an expert and he's talking in vague terms, so you should press your guest to talk in more specific terms. That's one of the things. So you should be aware of this. So it's an important idea. That's why we, let's just, okay. So we'll see, this alarm seems to be a few seconds late, but since we are here, we'll just, so anyone who comes now will be absent. Let me just pause see, this alarm seems to be the alarm is not going off. You want to hear what the aliens sound like? Okay. So let me just pause the recording. All right. So the importance of that, the Popperian distinction. Okay, and so let's go back now. Let's continue towards the end. So what we have done with this, did I discuss utilitarianism in your class?
No.
Not yet. Okay. So I think let's do this, although we are not going to, I just want this to be, we're going to put this in your syllabus. But what I will tell you is that since we are spending so much time discussing it, we might as well put it in, and it's useful for you to know these terms. If you've done a course on law, you should know these terms. So let's remove the italics. And so you don't have to, I mean, there's a lot of information here. It's actually taken from, I forgot to put in the credit. This is actually taken from a very good website, couple of websites. I'll give you the links later on. Actually, I should have put in the links here itself. Okay, so all you need to know about ex ante and ex post is which is similar to, how does it match with the normative positive distinction, okay? Or the positivism, formalism versus realism distinction. So a lot of it is actually explained there, so you should just have a broad understanding of that. It's important that you should be aware of these terms, okay? Ex ante, ex post, because this may come up in economics and other business related distinctions as well, okay? So you can just read this. I broadly explained this to you, right? That ex ante is basically essentially you take is similar to the consequentialist perspective, okay? And it's similar to legal realism, where you try to think about what will happen if we make this, what will be the consequences. Just like if you go back to the Shabana judgment, they were thinking about what would be the consequences if we decide the case in this way, and then they look at the consequences, and if they like it, then they rule in that particular way. Otherwise, they rule in a particular way which produces the consequences that they want, okay? So therefore it is similar to realism, okay? So that is what is the ex ante perspective. And the ex post perspective is more like formalism, where the judge basically just looks at, okay, what was the rule, and then, okay, if you violated the rule, then you'll have to pay a penalty, and we don't really care about the consequences, okay? So so this is basically the distinction. Just read up on it, the rest of it on your own, okay? And then here, consequentialist versus deontological. And deontological is much more like the ex post perspective. It is much more like formalism. It is once again like you compare it to a code, some kind of a set of laws or a moral code which you have violated, and then you will accordingly face the punishment. Okay, so we don't really care about the consequences of deciding in this way. This is the rule, and then if you violated the rule, you will face the consequences. So it's much more like legal positivism, much more like formalism. Okay, and in a way, the connection to the positive normative debate is a little bit weaker, but you can say this is the deontological perspective is more like the positive approach, that you say that, okay, this is the law, okay, we don't really care about what the law should be, because when you're going into the ex ante kind of discussion, okay, or the consequentialist kind of discussion, okay, like they did in the Shavano case, they actually started thinking about what should the law be. Because if the law is, if we interpret the law to be just what the black letter law says, then we get a consequence where this woman is out on the street, okay, and she has no way to fend for herself, and that's not a good consequence. So therefore we should rule in a different way, which produces a better consequence. Whereas in a deontological perspective, you don't really care about the consequences. You just care about what the law says, and you will rule according to the law. If you have violated the law, yeah.
So then what's the difference between ex post and deontological perspective?
It's very similar. If you read the notes, actually, that's why we are saying that these distinctions are all very similar. That's why I'm discussing all of them together, right from normative, positive. So deontological and ex post is a very similar kind of perspective, okay? So just that certain domains of the law where one term is used more than the other. So you can just read this, but you're right that they are the same, okay? They are basically on the same side. Whereas ex ante is much more like the consequentialist approach, okay? So therefore it is more similar, it is closer to the normative approach. Whereas this is more closer to the positive approach. We look at what the law is in the deontological perspective or the ex post perspective, and then we rule accordingly, okay? So we don't really apply our mind to whether the law should be like this or it should be like that. This is what it is, okay? And that's all we care about. All right, so these are quite important. I think as part of your training, you should be aware of these kinds of judicial philosophies. So one important aspect of consequentialism, which we should be aware of, again, this will have some kind of connection to economics as well. When you make economic policy, this is one of the philosophies that is often sort of alluded to. So there is this guy called Jeremy Bentham, who is known generally as the father of what is called utilitarianism. Okay. So essentially, what is utilitarianism? It's the principle that when you're thinking about policy choices, okay, the policy that you choose should be the policy that produces the greatest good of the greatest number. Okay, so let's put it this way, maybe the optimal policy choice. You understand what is optimal, right? That is the one which we choose essentially, so which is chosen to be the best policy. So the optimal, brief definition of utilitarianism will be the optimal, let's make it quite specific into economics, but you can actually look at, so let me not actually do that, that would make it too restrictive. It can be any kind of policy, it can be economic policy, social policy, okay? Like for instance, we have this new law, although we had section 125 CRPC already, but the Modi government has recently made a new law which is the maintenance, I don't remember the exact name, but it's the maintenance of parents or something like that. So essentially it obliges children to maintain their parents. Okay, so this is obviously a social policy decision. You could have also decided not to make such a law, but they have chosen to make such a law. So this is a socio-political policy decision, more social actually. So they make this. So if you are following utilitarianism, you would make these kind of policy choices based on what will produce the greatest good for the greatest number of people. Okay, this is the idea behind utilitarianism. So the optimal policy choice should be one that should be the one that produces the greatest good for the greatest number of people. Okay? Because normally our policy, the people who are subject to the policies are the people. Alright, so this is basically the idea. So greatest good of the greatest, sometimes it's expressed as the greatest happiness of the greatest number, but this is the idea in utilitarianism. So it's an important concept to be aware of as business students. They'll be aware of this guy Jeremy Bentham and this utilitarianism. So utilitarianism is actually, can you see that it is very similar to consequentialism? Yes. Because you're already explicitly focused on the greatest good of the greatest number. Good means good is a kind of consequence. You could have also thought about producing the greatest bad for the greatest number. So that would also be a consequence. Okay, so it's a consequentialist approach because you keep tinkering with, you keep evaluating policy choices and you evaluate their consequences. So therefore, clearly it's a part of the consequentialist approach, okay? So it is a specific type of, it's a specific subclass, you could say, of consequentialism, right? Where just like we said that textualism is a subclass of formalism, okay? And we also said that originalism is a subclass of textualism because originalism applies only to the constitutional interpretations, okay? Whereas textualism is a broader philosophy for all kinds of laws. Not just the master law like the Constitution. So utilitarianism is basically this. Okay, so it's a subclass of consequentialism. So it's important to be aware of this because in many economic policy choices, this idea comes up. Okay, and so the ontology also I broadly discussed. So I think we can end this debate here. This is essentially all these things which are similar. All these have very similar distinctions. Okay, so you can see how many of them there are. And so this ends this particular module. Okay, so we'll move on to the next part of the discussion, which is this topic, which is the next topic, is the three organs of the state and the doctrine of separation of powers. Okay, we haven't covered this in this class, right? Okay, all right. So here, this is the classical political science doctrine. Some of you might have done it as political science in your political science classes. So it actually originates from this guy from, I think we might as well write his name here. This is actually comes from this guy called Montesquieu. He's a French writer. I don't know how exactly to spell that. We got to check that. That's obviously not the right spelling. Anyway, I'll check the right spelling and write it. His name is Baron de Montesquieu. I have to check that and I'll write it later. Okay, so I'll just put a question mark so I correct the spelling later on. Okay, so he talked about these three organs of the state. Okay, so you have the state and you have the three organs, essentially the legislative branch, the executive branch and the judicial branch. Okay, so you have to be careful about, we'll talk about their functions, but you have to be careful about how you speak about them. Okay, so if you're going to use the word branch, okay, sometimes we say the three branches of the government or the three organs of the state. So if you're going to use the word branch, then you say legislative branch, executive branch and judicial branch. You do not say judiciary branch, okay, or you do not say legislature branch. Okay, so either you say legislative branch, executive branch, or judicial branch, or you say the three organs of the state or three arms of government are the executive, the legislative, the executive, the legislature, and the judiciary. Are you following? Yes. So if you're using the word judiciary, then it should be on its own. If you're using the word legislature, it should be on its own. But if you're using the word legislative or judicial, then you pair it with the word branch. Okay? But do not say legislature branch or judiciary branch. Okay? So that's what you have to be careful about. The executive, the word executive does not change. Okay? So if you look at the purer form of separation, the country with the one major country with the most pure form of the separation of powers is the US. Okay, their separation of powers is much purer than what you see in England or India or Canada, Australia, etc. Okay, so what happens? Why is it purer? Because if you see the US, who's the head of the US executive branch? The president. Okay, so you see that Donald Trump was separately elected. Okay, he has nothing to do with the legislature. He never comes and sits in the legislature. Okay, so there's a direct election and a separate election for the head of the executive branch, and then there are separate elections for the for the people who constitute the legislative branch. Okay, so that's why it's a much purer form of separation of powers, and they are quite strict about it. And in fact, there's a very famous US Supreme Court justice who is now passed away, called Antonin Scalia, and he actually mentioned why. I mean, he was asked about why the US is such a free country. Okay, it's still considered one of the countries where people have a lot of freedoms. Okay, you can say whatever you want. Like in India, if you see freedom of speech, there are all kinds of restrictions, okay, on what you can say. But in the US, there's a lot more freedom of speech. You can actually say all kinds of things. There are people actually who are Nazis who are actually saying things negative about the Jewish people, but that's allowed under US law. You can actually, because there's tremendous freedom of, there's quite a lot of the idea of freedom of speech in the US is quite wide. Okay, and as you know, they have the right to carry guns, etc. So they have a lot of freedoms. Individual liberty is quite high in the US, okay, if you look at all the other countries. So Justice Scalia was asked about what makes the US, or what has made the US so successful, and what has made them, why is your liberty, why is there so much personal liberty in the US? And so the answer he gave was really that it's all down to the separation of powers. Because the powers are clearly separated and there are checks and balances between each of the branches. So that essentially prevents any kind of tyranny. Okay, so the reason that Montesquieu came up with this idea of separation of powers is because he wanted to prevent tyranny. You understand what tyranny is? Tyranny is basically, just one person ruling in an arbitrary way, and usually not for the welfare of the people. So you could say that, maybe you could say that Saddam Hussein was a tyrant in in Iraq. You could, in many ways, you can say those who are being persecuted in China, they might say that the Chinese Communist Party is tyrannical because they have complete control of everything.
So more of a dictator.
Yeah, like a dictator. Okay, so but dictator, sometimes you can have theoretically, you can have a benevolent dictator. Okay, who is a very good, king. For instance, a dictator like king, if you look at Samudragupta or Ashoka, these are all good kings. They also had, absolute power. But they are generally seen as people who did a lot of good for the. Akbar is also seen as a king who had a lot of power, but he's seen as a benevolent kind of dictator. But normally when we use the word tyrant, we use it in a completely negative sense. You never have a good tyrant. Okay, so the word tyrant is always used in a negative sense. Okay, so you can think of maybe people like Saddam Hussein as a tyrant. So many people think that the current regime in Iran, the Ayatollah regime in Iran, the Islamic Republic of Iran now, after they had the revolution in '79, that is also seen as a tyranny. There are lots of protests going on the streets of Tehran. Sometimes you have these, but they suppress them. So tyrannical means somebody who has a tyrant is someone with absolute power and is generally oppressing his people, not doing good for his people. Okay. So essentially, what he said was the reason we have been able to prevent tyranny is because we have separated powers quite strictly, and so each of the branches acts as a check and balance on the other branch, and nobody has concentrated power. Okay, so if you look at the functions of the three branches, you'll understand this a little bit better. Okay, these are all important questions from political point of view, and politics is actually quite important. If you see, at the end of the day, it can affect your life. So so if you see now, if you briefly look back at what the functions of the three branches are. So the legislative branch, what do they have to do? They have to make laws, right? So all the laws that we have, like recently we had this,
Parliament.
Yeah, so parliament, you have parliament in India at the central level, and then you have the state legislatures. Okay, so there is already in our constitution there is a separation of subject matter in the union and the state lists and the concurrent lists. we have a separation of the states can rule on these matters and the central can rule on these matters. So they take their subject domains in which they can make laws, and essentially the legislative branch is concerned with making the laws. Okay, so we had recently, if you see in the commercial realm, we had this, so now we'll have to start implementing the negative marks. So Sejal and Pragati, you're having a conference at the back. So we will have to start out with our first negative marks, otherwise this talking business will not end. Okay, now Sejal and Pragati, are you in the same team? We have to find out where they are. Okay. Okay. So Sahib is notching, opening his account. Okay, and where is Sejal? Oh, same team. Okay. All right. Okay. So the rule we'll follow is the same team, two people talking. It will still be -2, not -4. So generally, if you want to talk, better talk with somebody on your own team, so that you'll minimize the systemic losses. Okay. All right. So this will I will take care of the formulae later. But let this remain. I'll just want to notch up the score. So don't worry about the totals right now. I'll correct this stuff over the weekend. So I just want to make this in bold. All right. Okay. Okay. So let's go back to this discussion. Okay. So the legislature is concerned with making laws. Okay. So recently we had this in India. One of the most prominent pieces of legislation recently has been the Insolvency and Bankruptcy Code, which is called the IBC. It came in 2016. Okay, it's quite a remarkable piece of legislation, because all around the world people are saying that this is one of the fastest pieces of legislation. Okay, but of course we had to make a lot of amendments later. But it was introduced very quickly. The idea was mainly to clean up. You know what it's about, right? The IBC. You guys have to know about all this. You're not involved, not informed at all. You're not plugged in. I've told you to follow the Bloomberg Quint website for Indian news, because this stuff is happening almost every day. There's some news on the bankruptcy process, because all these steel makers, many of these steel makers have gone bankrupt. There's a lot of tussle. There's a lot of tussle about there are tussles over taking over these bankrupt, because this ArcelorMittal is trying to take over one of these steel, I think SR Steel's plants, and then some other people are trying to fight with them over that. So this stuff is going on all the time. So this news, you guys are not plugged in at all. So you should have already heard about all this stuff. You're business students, remember, okay? You're not like English literature students or something like that. So you're postgraduate business students. You need to be completely plugged into what is happening in the world of business, both in India and internationally. Okay. So the IBC is an example of important legislation. The Insolvency and Bankruptcy Code, it tries to speed up the bankruptcy process. So the main idea was to essentially take to basically quickly resolve the bad loan problem on the books of the public sector banks. You know that the public sector banks have a very big bad loan problem. So you have the high profile cases like Vijay Mallya and Kingfisher, and then you also have Nirav Modi, okay, all these cases, but there are actually many other low profile cases also, but there's a big problem of non-performing assets on the books of the public sector banks. Because there's obviously, because it's a public sector, this is one of the big mistakes that we have made. This is what Indira Gandhi did in, I think, 69 and 71. She did another Brit, and we never managed to reverse it. So this, as long as this is a massive drain on taxpayer funds. This every year, because every year these public sector banks have to be recapitalized. Okay, and so there's a huge amount of money that is going in, and there's still losses, because obviously public sector, no one cares. If it had been a private sector bank, the losses are much less. Because when it's your own money, you count even 5 paise. But public sector, no one cares. It's just going here and there. So there's a lot of corruption also. They bribe the officials and get loans when they're not eligible for them. So anyway, so the legislature is tasked with making laws. Understanding what the problems are in the country, what kind of laws need to be introduced, and they make laws. Okay. The executive branch is, what are they supposed to do? Bureaucrats implement the laws, okay, enforce the laws, okay. So the police is part of which branch? Executive branch, okay. So the police in India we have the system where the police is under the state government, but they are considered as part of the executive branch, okay. Although it's interesting that many of the laws that the police enforce, actually, if you see, the main law that the police enforce actually is a central legislation, although the police are under the state, and they are considered to be part of the executive branch of the state, okay, other than union territories like Delhi, but largely they are under the state. But the main law that the police are enforcing, which is the Indian Penal Code, That is not a state law. There is no difference between West Bengal and Maharashtra or anything like that. That is a central legislation that applies all over the country. Okay, so the police enforce that. So the police are part of the executive branch. And of course, as Chug was saying, these are all the bureaucrats. All the bureaucrats are considered part of the executive branch. Okay, so you have all the IAS officers. Okay, and you would also consider there are also certain bodies like Reserve Bank of India, SEBI. You heard of SEBI?
Yes, sir.
Okay, so all these, Securities and Exchange Board of India, which is the main securities regulator. So all of these would be considered as part of the executive branch. Okay, although these are actually considered as statutory authorities. But when you're looking at the scheme of government, you would still put them as part of the executive branch because they're largely answerable to the government. Okay, to the so the head of the executive branch in India, who is the head of the executive branch? No, central government, but who? Which person? Prime Minister. Not technically speaking, the head of the executive branch in India, according to the Constitution, is the President. Okay, but he's the what we call it as the de jure head. That is, these two terms that you should be aware of. Okay, de jure and de facto. Okay. Okay, and de jure means by law, and de facto means in fact. All right. Okay, so the de jure head of the executive branch in India is the President of India, but the President is required to act according to the advice of the Prime Minister and the Council of Ministers. Okay, so essentially, in fact, you could say that de facto the head of the executive branch is essentially the Prime Minister. Okay, so this is basically so you can also say that I think in that in the days of Jahangir, the rumor was that actually Noor Jahan was making all the policy decisions. Okay, so you could say that the de jure head of the kingdom was Jahangir, but the de facto head was Noor Jahan because she was actually pulling all the strings from behind. Okay, so that's how you use these terms. So anyway, so what happens is the Prime Minister here essentially is the de facto head of the executive branch. And the other thing to notice here is that in other countries that I mentioned, in countries other than the US, okay, you'll notice that we have the similar system in the UK, in Australia, Canada, etc. What happens is that you see that where, let's say, Mr. Modi is the head of the executive branch, de facto head, okay, he's the Prime Minister, but he's also sitting in the legislative, in Parliament, okay, when he has to vote on laws, he's also sitting in Parliament, he's also an elected member of Parliament. Okay, so what happens in most of these countries like India, UK, etc. There's the head of the majority party in Parliament becomes the Prime Minister. Okay, so which is the the de facto head of the executive branch. So whereas so essentially the Prime Minister in these kinds of setup, he functions in both capacities. When he's sitting in Parliament, he's functioning as part of the legislative branch. He's sitting and voting on Parliament and debating laws, etc. Then he's part of the executive branch. But when he comes to the Prime Minister's office and issues directions as Prime Minister, etc., then he's part of the executive branch. This is clear? So there is a certain amount of overlap in most of these countries like India, UK, etc. But you don't have that in the US, where they have a much purer form of separation of powers. Okay? So the job of the executive is really to enforce the law, and this would include the statutory bodies like so you have the Prime Minister and the Cabinet, okay? And then you have all the other ministers of state, etc. And then you have the bureaucrats, and then all this, the regulatory bodies, okay, like SEBI, RBI, etc. And then judiciary. The role of the judiciary is to interpret the law. Okay, so essentially that's what we saw. So these are if you just sum up the three major functions, the three functions of the three branches of government is the legislature is supposed to make the laws. Okay, the executive branch is supposed to implement the laws. Okay, and enforce the laws, and then the judiciary's job is to interpret the law. Okay, so now if you go back to the distinction that we discussed between legal formalism and legal realism, okay, if you go back to that distinction, which of those two judicial philosophies, formalism or realism, which of those two philosophies do you think is more consistent with the separation of powers doctrine? Okay, why let's use the mic and let's hear the answer. Who wants to answer? You can answer. Answer. You were the one who you jumped out first. Okay. What's your no? Tell us what's the answer.
Sir,
Your answer is what? Formalism or realism?
realism.
Realism. Okay. Why? Justify your answer.
For the legislature, they make the law, so they think of the consequences, to think of the reality, which is going
Okay.
on, what is the need of the society, and then they make the law. So that is the realism part. And when we come to the judiciary, it is the formalism. They interpret it and they follow as it is written.
Okay, so my question was really more about on the focus on the judiciary, because my question was between legal formalism and legal realism. These two judicial philosophies, when we compare these two, which of these two philosophies is more consistent with the separation of powers doctrine? Okay, let's give Gulati the mic, although he doesn't really need a mic, but he's give him the mic anyway. Let's practice passing the baton. Yes.
So according to me, realism would be the better choice, because with the separation of powers, even the person who is giving who's making the decision.
Your voice is not coming through the mic, by the way.
That is not working.
Oh, the mic is not working today.
Yeah.
Okay, I don't know why. Maybe they haven't switched it on or something like that. Okay. Anyway, okay. Let's not waste time now. Just tell me what. Yeah. So you're saying realism is more consistent
Yes.
with the separation of powers doctrine.
Yes.
Why is that?
So because they can also think about the consequences before implementing the law.
Who is they?
The
judges.
The judiciary.
The judiciary is supposed to can think about the consequences before implementing the law. But what does the separation of powers doctrine say about the role of the judiciary?
Interpreted. They interpret the law while applying it to specific functional situations.
Yeah, factual situations and pronouncing judgments in cases. Essentially applying the law, okay, interpreting the law. So why is realism more consistent with this? Because separation of powers says that the role of the judiciary is to interpret the law, right? Because it says the role of the legislature is to make the law, the role of the executive is to enforce the law, and the judiciary's role is to interpret the law. And you're saying that realism is more consistent with this approach, with this philosophy.
Sir, we can take the example of Shahbano case.
Yes.
They didn't implemented the law blindly. Like
They didn't implement, you mean, not implemented. They didn't implement. Yeah.
Like the legal formalism. Sorry, I didn't get the word.
Formalism, yeah.
Yeah. They just reached it, and then they use the philosophy of legal realism, and they implement the law.
Okay, let's hear another answer. Anybody else has a view? Is my question clear? Between, when you're comparing these two philosophies, judicial philosophies, what you've understood, legal formalism and legal realism, and then what you've understood now about the doctrine of separation of powers, which clearly demarcates the powers or the functions of the three branches of government. Okay, between formalism and realism, which of these two judicial philosophies is more consistent with the separation of powers doctrine? That's my question. Is my question clear now? Okay, so what is the answer? So his answer is realism. Her answer was actually more mixed, but I got your answer, what you said. Okay, so anybody has any other view? Okay, so actually there is a correct answer in this case. Actually, the answer should be legal formalism, because think about what the separation of powers doctrine says. It says that the role of the judiciary is to interpret the law. Does it say that they should be making the law? It doesn't say they should make the law. Okay, so therefore the judiciary, under the separation of powers doctrine, they have a very specific and limited role. That is only to interpret the law, which means essentially, if you go back to the definition of formalism, there you see it says that the role of the judge is to apply the law and not make the law. Okay, so interpret the law or apply the law in a particular situation. So therefore formalism is more consistent with the separation of powers doctrine. Okay, because here the judges are actually under formalism. They stick more to their classically defined role under the separation of powers doctrine, which is only to interpret the law. If you see in the Shabano case, they were not really interpreting the law in a faithful way. They actually decided that the law, if it was interpreted in a faithful, in a mechanical way, it will create a consequence which we consider to be socially undesirable. Okay, so therefore they essentially, in a way, they made the law. Okay, so they made the law, so they have rewritten the law. Okay, so this is sometimes referred to as legislating from the bench. Okay, so the bench where the judges sit, that's called the bench. Okay, and where the advocates are, that's called the bar. Okay, so that's why sometimes you have a legal website called Bar and Bench, things like that. So that's what it's referring to. So so this is sometimes referred to as legislating. What the Supreme Court is a case of legislating from the bench. because they did not follow the law as it was strictly written down, and they actually made a law in that particular situation. They made a new law. So they were actually legislating from the bench. So a person who believes in the strict separation of powers would not agree with that kind of approach, because they would say that the judiciary is now stepping out of its bounds, because under the separation of powers doctrine, their role is only to interpret the law and apply the law, not to make the law. Okay, so again you can see, so that's why you'll see again, as I mentioned to you earlier, this is actually a debate which we should be having in a more public way in India, but we don't really have this debate. But in a country like the US, you'll see there's a very active debate on this. They actually select judges. So if you see now Donald Trump, as I told you, his philosophy is he believes in formalism. So he's actually selecting judges who believe in the same judicial philosophy. And in the US, judges tend to be much more consistent about whether they follow realism or texture or formalism. They tend to be much more consistent either way. Okay. So whereas in India, as I showed you from the two judgments of 1985, the same judge can waffle between formalism and realism within a month. Okay. And that person is actually the Chief Justice of the Supreme Court. Okay. So because this happens because we are not explicit about these philosophies and we don't discuss them openly. Alright, so this is again something to be aware of, that formalism as a judicial philosophy is much more consistent with the doctrine of separation of powers. So if you go back to what I was saying about Antonin Scalia, who's the Chief Justice, who was the Justice of the US, Associate Justice of the Supreme Court, now no longer, he's passed away. So he's considered one of the great justices of the Supreme Court in the US, and he actually believes that the reason that the US has maintained so much personal liberty for its citizens is because they had a strict separation of powers, okay, and there's a check and balance between the three branches of government, okay, the checks and balances, and that's what has actually prevented tyranny. So usually tyranny happens when, now you know what tyranny is, right? Yes. Okay, so tyranny usually happens when there's a concentration of powers. Okay, think about it, like if I make the law and I also interpret the law, then I have more power. Whereas here, if you see, the legislature makes the law and then the judiciary interprets the law. Okay, so you can see how checks. Yeah.
Sir, but why in the theory of doctrine of separation, it is more specifically stressed on to follow legal formulation? Why not legal realism? If they have separated the powers of every department, then still, why are they still making it to follow the legal formulation? Why not legal realism?
No, because see, this under the doctrine of separation of powers, the classical doctrine of separation of powers, the role of the judiciary is only to interpret the law and apply the law, and it's implied that they're supposed to do it in a fairly mechanical way. The law as it is laid down by the legislature. Okay. Whereas if you apply legal realism as a judicial philosophy, in many cases the judiciary would end up making the law. Like I gave you another example of the Delhi Rent Control Act, where one of the judges said, where the legislature has written down in the act as it is, it says this particular provision applies only to residential premises. Okay. Now this particular judge basically decided on his own that no, this is not the correct way to write the law. According to me, this provision should apply to even commercial premises. Now that's a big change, because residential commercial is a very big difference. So you can see here so this judge obviously believes in whether he understands it or not, whether he articulates it or not. He obviously believes in legal realism. So he's making the law as a judge, because the legislature said only residential premises, and he expands the scope to even commercial premises. So that's an example where a judge is actually making the law. But under the separation of powers doctrine, we don't see that as a role of the judge. Okay, the judge's role is only to interpret the law and not to make the law. Okay, so that's why we don't consider legal realism as being consistent with separation of powers. Okay, so you can see in the US this has happened many times, where lots of places where judges have made the law, like abortion, as I told you, is a big debate in the US. So there was a decision called Roe versus Wade in the US many years ago, where the US Supreme Court essentially said that every woman has a fundamental right to abortion. Okay, whereas if you look at the US Constitution, where they have enumerated the rights, okay, there is no such right as a right to abortion. Okay, there is a right to life and a right to property and a right to liberty and all these things, but there is no right to. So it's not written down anywhere in the Bill of Rights, etc., which they have. But so there's no formula. But the Supreme Court basically just decided that we are going to make this as a fundamental right of every woman to have an abortion. Okay, so that's an example again of legal realism. So a judge who was following the judicial philosophy of legal formalism would not have done that. Okay, so that bench, obviously the majority of the judges, they believed in legal realism. Okay, so in fact in the US, largely from the 1930s there's been a strong movement in favor of legal realism. But only now, today, what is happening is with Donald Trump has actually been able to appoint a lot of these formalist judges, people who believe, they call them textualist judges because they use that term much more often in the US. So he's now trying to actually tilt the balance in the federal courts, okay, towards more textualist judges who will basically believe more in formalism, okay. So this is a tussle that is going on, and it's quite interesting to watch actually. So anyway, so is this clear now, guys? Okay, separation of powers. Okay, now, well, so this idea of the three branches of government, okay, this is what you see in classical political science doctrine, okay. Now, what you don't see, but what I'm going to discuss, that there is now the talk, because theory has to evolve to accept, theory must evolve to capture what is going on in the real world, okay. So one of the interesting things we have seen, especially in a very sort of egregious way since Donald Trump was elected, okay, and the information that has come out since then. If you see what has been happening, there's this, have you guys heard this term called the deep state? Okay, what I've written here, the deep state, let's go back a little bit. Now we've already seen the first. Now we are talking about, now this you will never find in a political science textbook, okay? But I think it's an idea that you should be familiar with because it's a real possibility. It has happened very much in the US, but it can technically happen even in India, okay? So think about the executive branch of government. What did we say? That it includes the prime minister and the cabinet, but it also includes all the bureaucrats, like so all the IS officers, okay, then all the other RBI and all these other people, SEBI, everybody, all the extended regulatory bodies. Okay, so now this basically, now what happens is, see, the prime minister and the cabinet obviously are, every election they are at risk, okay. They may not get re-elected. In that case, the prime minister will change, okay, and the cabinet also will change. All the finance minister and home minister, all of that will change, okay. But do you think that the IS officers will change? Okay, they may transfer some of these people here and there. They might get their pet officers, like Modi got all the high performing guys from Gujarat and he got them to the center and all that because he trusts them. So, but that may happen, but they still remain within the IS cadre, okay. So this, basically this now, so you see that actually because those IS officers are not elected. They are what we call unelected, okay, officials, okay. Unelected officials, and usually they serve till they retire, okay. And so, so now this is what is called the deep state, where essentially you have some part of the executive branch of government, okay, some part, because one part is kind of obviously elected, so they are subject to the election cycle, okay. In India it's 5 years, in the US it's 4 years, okay. In some parts of the US legislature it's every 2 years. The House of Representatives in the US, they have to stand for election every 2 years, okay, and in the Senate they have to stand every 6 years, okay. So there are some differences, but let's say broadly about 5 years, 4 to 5 years. Everybody is subject, the elected officials, the elected politicians are subject to the election cycle, okay. They can get knocked out at any stage. But the unelected bureaucracy, the IS officers and all the other federal officers in the US, they are never, they actually serve till they retire, okay, and they are not elected. But they have a lot of power, okay, they have a lot of power. So one of the things that happened in the US before this, during this election cycle, is actually what is emerging as information now is that the members of the FBI, because Trump had come out with a very strong statement about cutting the size of government and all that, cutting down the bureaucracy. So a lot of these guys did not like Trump. So what they were doing is they were actually spying on him, the FBI, the CIA and the NSA. They were spying on a presidential candidate, and even after he got elected, they were trying all kinds of tricks from behind, basically, because the government is so big, you can't control it, okay. So essentially this is what is happening. This is what is called now the deep state. So the deep state essentially is the unelected, okay, we can just call this here, I'll just write it here, unelected bureaucracy, which is a part of the executive branch, okay. And so these guys have a lot of power. So they abused a lot of, because the National Security Agency in the US, they collect in the name of monitoring terrorists. They are actually monitoring all the phone calls. Every phone call, every email exchange, everything is being monitored. Not at a micro level, they monitor the metadata. Okay, so if I'm like calling you and discussing, okay, let's plan a terrorist attack at this, the public square, etc. So the moment we say terrorist attack, or we say bomb or something like that, so those keywords are being captured. Okay, so the metadata is being captured. So the NSA is actually monitoring all the calls. Okay, and then they have a system of getting warrants Okay, so if they feel that they capture us, if they see us talking about some planned terrorist attack, then they will go to the FISA court. Okay, there's the Foreign Intelligence Surveillance Act. So they'll go to a court and get a warrant to further keep tabs on you and all that. So all this stuff is going on. But this machinery was actually abused. So they actually abused this machinery and they started spying on the Trump campaign, even during the campaign. And even after he was elected, just imagine the audacity of these people. A president-elect, somebody who has been elected president, is serving in the transition and they are spying on him. That's why and so one of the people in the deep state itself, one of the NSA directors, he went and informed Donald Trump that this stuff is going on. So immediately he shifted they were in Trump Tower, and he shifted to a different location in New Jersey. So this is what was going on. So just imagine the audacity of the unelected bureaucrats, that they're spying on a presidential candidate and then on a president-elect. And even after he became president, they have been trying in many ways to undermine. Like if you see some of the stuff that is going on, he had a call, Trump had a discussion with the Australian Prime Minister, okay? He had a discussion with the Australian Prime Minister about some refugee exchange problem or something like that. And then the next day they had leaked the entire transcript of that call. Can you imagine? Say Modi has a conversation with the King of Saudi Arabia and somebody leaks the whole conversation to the press. So this should not be happening because obviously Australian Prime Minister, US President, they're talking, that's confidential, okay? But somebody basically in the network, they leaked the conversation, and it's very difficult to find out who actually did it because there are so many people involved. So this is what is going on. This is something that you should be aware of. As I told you, you should study the US because it's such a big country and such a developed country. You get to see all kinds of interesting phenomena, okay? And it will clearly remain the most dominant economic and military power even in your lifetime, okay?
That is why we've been told not to use this iPhone because even the Chinese are also trying to spy on his phone and calls.
Could be. There was a report recently, it has not been substantiated, but there was a recent report on the Bloomberg that the Chinese had actually infiltrated from small microchip. They had inserted into hardware that was supplied to Apple and I think even Microsoft or some other people, okay, so some other organizations. So there was like widespread infiltration. So the US in fact recently has come out with a request to its allies not to use Huawei equipment. Okay, so the US DoD stopped buying all this Lenovo and stuff, all that stuff made in China. They are all phasing it out.
So even the companies like Caterpillar, when their employees go to any country like China or any these countries, they are told to destroy their gadgets. So if they're traveling with an iMac or even an iPad, they are told to destroy after they use them. Because earlier when they used to go through the checking machine, the data used to get leaked.
Yeah, quite possible, absolutely possible, because we know that this is one of the things that in the trade talks. Okay, this is pure espionage, but in the trade talks, there's kind of a little bit of overlap with this idea because they're also stealing a lot of intellectual property. So China has been doing a lot of stuff in this realm. But I was talking more about, that's a slightly tangential topic, okay? But I was talking more about the deep state to understand to give you a flavor of what they've been doing. Okay, so this is something that technically I think that political science textbooks should actually now incorporate this because we have seen this happening on a large scale. Okay, so technically it can happen even in India because you could actually have a case of some people in our intelligence agencies, because even here we monitor everything. In fact, we monitor much more in India without people knowing, because we don't have all these kinds of in the US the Constitution there is a Fourth Amendment which gives you a right to privacy. Okay, so they cannot search your information without a reasonable without probable cause. Okay, so if they want to take so they need a warrant. Okay, but in India we don't have all these kinds of safeguards. So the government can search everything. Okay, so all your calls, everything you do, every site that you're surfing, everything, technically the government, if there is a suspicion that you are involved in some kind of anti-national activity, they can actually search it. But the point is that as long as the people who are doing all this stuff at the center are good, that's okay. But because all this monitoring is going on, suppose that I am some kind of officer, just like I'm in the National Informatics Center or somewhere, and I don't like a particular political candidate, I don't like their views, okay, I can actually try to monitor them, abuse the power that is given to me, and then I can try to monitor them and then use that information to their disadvantage. So all this stuff can happen. So you have to be aware of something called the deep state, which is, although we talk about 3 branches of government, okay, there is, because we have seen the deep state in action big time in the US now, in this particular, after 2016, during 2016 and also after 2016. So so this is just something to be aware of. Okay, I've given you a little news story. You can read that. Okay, all this stuff. So a lot of stuff which we are discussing, maybe not typically discussed in a legal business law course, but I think it's useful for you to have all this information. Okay, guys. All right. So next, go on to any questions about this so far? Okay, you should be familiar with this term called the deep state. Okay, which is the unelected fourth branch of government. Okay, so now foundational legal theory. We'll study a few terms again. Let's just something that you have to be aware of. Okay, read this book, this article, this. Okay, this article is in your folder, the readings and statutes folder. Okay, I've given a link also here. If it doesn't work, just go through the folder. Okay, just read page 1 of this. Okay, for your own homework. So essentially, I just briefly explain what this is. Okay, civil law essentially is what you see in countries like continental Europe, essentially. Okay, so and you also have it essentially in Japan, Russia. So it's what you see in Europe, in Germany, France, all these countries. Okay, this is what is called civil law, and what you see in the Anglo-Saxon countries like USA, I mean, all the stuff that basically all the countries that are former British colonies. Okay, so UK obviously. Itself, and then Australia, New Zealand, Canada, UK, USA, India, all these countries. Okay, so we are called common law jurisdictions or common law countries. Okay, so jurisdiction is just an area. Okay, so the two terms that we use are essentially either we have a common law system or a civil law system. Okay, we'll understand what they mean. But so actually just get the nomenclature right. So civil law is what you have in all these European countries, the continental European countries, and common law is what you have broadly in all the English colonies. Okay. So, and what is the difference between, and so the other term that we use is that civil law is an inquisitorial system, whereas common law is an adversarial system. Okay, so understand first what an adversarial system is. You understand here that the system we follow, which is the common law system. Okay, so you have the two advocates when there's a dispute in the court. The two advocates present the case for each of them, for their clients. Okay, so they are like, you know what adversary is, right? Adversary means opponent, right? So adversarial, so that means that there are two parties opposed to each other. So that is what is meant by the adversarial system, that each of the advocates will go and speak for their clients. Okay, so they will present their argument, and then there will be counter arguments by the other side. Okay, so they are functioning as adversaries to each other. So all these common law countries, Australia, New Zealand, India, UK, all these are USA. This is how the system. These are all adversarial. They follow the adversarial method. Okay, of dispute resolution. And so that means essentially two advocates argue the two sides, okay? And then the judge will decide who makes a more persuasive case. And then under civil law systems like what you have in Germany, France, etc., we call this an inquisitorial system because here you don't have two advocates as such, okay, arguing material, okay? Normally here what is happening is the judge actually is driving everything. So the judge will ask questions. Okay, what did you do here? Can you show me these rent receipts? Okay, can you show me the evidence of that particular? Can you show me that maybe the videotape of that incident? So that here the judge is actually conducting the whole proceeding. Whereas in a common law system, the judge is a little bit more passive. Okay, he just listens to the argument. Okay, and technically a judge is not required to make out a case for you. So if your advocate does not mention a legal point which is actually in your favor, okay, the judge is not obligated to mention that for you and take that into consideration. He will just take what the advocate has presented, okay, and he will just rule accordingly. So if your advocate has not made a good case, then the judge is not obligated to make that case for you, okay. But whereas in the inquisitorial system, the judge plays a much more central role, and he basically conducts an inquiry. So it's like he's conducting an investigation. Okay, that's how the system works. Okay, so these are just some broad ideas that you should have. Okay, as now another important thing which will come to, which is there in the Landon Williams article also, that the idea of the main difference between civil law and common law systems is the importance of judicial precedent. Okay, and the way we will understand what this means. But the way this works is that in common law systems, so the main difference is that in common law systems, judicial precedent is important, whereas in civil law system it's not important. Okay, let me just write this down more explicitly. So and here. So this is how we distinguish between the two. Here judicial precedent is very important, okay? Then we'll understand what judicial precedent is. So we are just, at this point, we're just labeling things, okay? We're not really going too much into what, except for the part where we discuss inquisitorial and adversarial. We're just labeling things. We are just saying that there are two broad legal systems, two broad types of legal systems: civil law systems versus common law systems, and you know where they are. And common law is an adversarial system, whereas civil law is an inquisitorial system. So inquisition essentially is a type of inquiry, okay? You might have heard of this expression called the Spanish Inquisition. You know, those of you who studied history, there was a Spanish Inquisition, historically about, essentially to do with, enforcement of Christianity and things like that. So anyway, that was also a pretty tyrannical kind of time during the Spanish Inquisition. But anyway, so inquisitorial means that essentially an inquiry, kind of aggressive kind of inquiry. So judicial precedent is another term that we are learning, and we are learning that civil law systems, judicial precedent is not important, and in common law systems, judicial precedent is very important. Okay, so this is one of the important distinctions between, the most important distinction between the two systems. So let's understand what is meant by, I'll come to this part. So judicial precedent essentially means, I'll just briefly explain what it is before we go into it in detail. Judicial precedent means essentially that you might have seen some of this in your Glanville-Williams article, that once on a particular set of facts, okay, if we decide, if the judge decides a case in a particular way, okay, precedent, you understand what precedent is? Precedent means something that has happened before, which is supposed to guide what is going to happen later, okay, that is the full meaning of the word precedent, okay. So therefore judicial precedent means essentially that the manner in which a case has been decided earlier, okay, that is supposed to be important in determining how the same type of case is decided in the future, okay. That is what is the meaning of, we'll see more details of it, but that is broadly what it means, okay. So the judicial precedent, the judicial decision on a particular case, okay, on a particular set of facts, okay. If you see that there was a case where somebody has negligently driven a car and run down somebody and that person has died, okay, and then the judge, based on the facts of the case, where you have this guy, where the judge notes that this person was driving negligently, okay, and he has hit this person, and then he has led to that person dying, okay. Then on that set of facts, if the judge gives a particular decision that this person is guilty and he should have this kind of liability, okay, then in the future, if you have a similar case where again there is a person who is driving negligently and he runs down a person and the person dies and the victim dies, okay, then the meaning of judicial precedent is that the previous case, however that was decided, the current case should also, it should be decided in the same way, okay. So it's essentially an argument for consistency. You can see in one word, if you want to sum up judicial precedent, it is about consistency. That on a particular set of facts, one person is driving negligently, he runs down another person, the victim dies, and that person, the driver, is given a certain penalty, okay. And then in the future, if the same set of facts happens again, then the idea is that the ruling should be consistent. The next, in the subsequent case also, the ruling by the judge should follow what the previous ruling was, okay, the same kind of penalty, same kind of liability. Is this point clear broadly? This is what is meant by judicial precedent, okay. So it's essentially about consistency. So the point is that in civil law systems, we don't really care about this judicial precedent aspect of it, okay. The civil law systems, as you will see when you read that particular first page, okay, the civil law systems are very heavily codified systems. Codified means there is written law, and they're supposed to follow what the law is saying, okay, and how a particular judge decided the same case earlier is not important to a civil law judge, okay. Whereas in a common law tradition, judicial precedent is officially considered important. So you can go, that's why you know that some of you might be aware that when we have cases in India, okay, which is the common law jurisdiction, there is a law, when you're arguing a case, one very important aspect of your strategy is what kind of precedents are you going to cite, okay. You will cite, like if you are going again for a fighting for maintenance for a Muslim woman who has been divorced by her husband, okay, and does not have adequate means to defend herself, to maintain herself. So one of the precedents you will cite is the Shabano case. Okay, so you'll see that here, you're going to cite in the court, you're going to say, see, remember that there was a Shabano case and the court ruled in this particular way. So here also in my case, in the case of my client also, you should rule in the same way and take care of this person. Okay, so this is how, so therefore in common law jurisdictions, the whole, this is one of the reasons when you're going to be studying judgments, and then when you study the judgments, you'll see that so many precedents are being cited. And then the judges are discussing all the precedents. Okay, so this is very important. So you can actually, in a common law jurisdiction, you can actually use judicial precedent to bind the court. You can actually say to the court that this case has been decided like this in the past. A case on similar facts has been decided like this in the fact. So you are actually bound to decide my case also in the same way. So you can actually put pressure on the judge by citing precedents. Okay, that's why these are very important. The precedents are very important in a common law jurisdiction, but in a civil law jurisdiction you can't do that because they are not required to care about that. Okay, every judge will reinterpret the law in his own way. Okay, ideally to be faithful to the law, but they are just supposed to interpret the law as it is written down, okay, in the civil law systems, and they are not supposed to be so worried about what the previous judge decided on a similar case. Okay, so you can't put pressure on a civil law judge based on a previous ruling in the same type of case. Yeah.
So in common law systems, it will be more formalism or realism?
No, common law systems normally, see, you can have both kinds of judicial philosophies within a common law system. But I understand why you're saying, you're probably asking this question because I said that in the civil law system, they are more tied down by the law as it is written down, and they are not so bound by the judicial precedent, right? So you probably think that the civil law system is more likely to be conducive to, or more likely to feature legal formalism. Okay, so that's correct. That is correct. But in the common law systems, again, you can see here, because the US is also a common law country, India is also a common law country, and as you can see in India, both kinds of judicial philosophies are prevalent, okay, even in the US. So if you come back to your question, okay, that in a common law system, is it going to be more characterized by legal realism or legal formalism? And the answer is, you really don't know. It can be either way, because the judges will subscribe, because you have seen this in India itself, that in the Shabano case, although we are a common law jurisdiction, okay, actually at that time there was no specific precedent on that particular type of issue, okay, but even in the future, but there's still, judges are actually still able to, if they believe in realism, they're still able to bring their philosophy into the way they decide the case, by sort of reinterpreting the law somehow, using some flexibility, because judges have a lot of flexibility, okay, so they can use that. In the US also you have this situation where, although they are also dealing with certain, statutes that they have to interpret, okay, or a constitution. But in interpreting the constitution, as you can see in the Roe versus Wade case, abortion, that is not mentioned anywhere in the US Constitution that abortion is a right. Okay, they have a lot of Bill of Rights, right to carry arms, right to keep and bear arms, that is explicitly mentioned. Okay, right to life, liberty, and life, liberty, and property. You cannot deprive anybody of their, we have also borrowed that from their constitution, okay, but we have left out the property part, okay. So in the US Constitution, it says that no one can be deprived of their life, liberty, and or property, okay, without due process, okay. So whereas in India, we have said only life and liberty, but the property we have left out, okay. So all those rights are enumerated there in the US Constitution, but it doesn't say anything about right to abortion. Okay, but then the court, just as they were interpreting the law, they just said, no, this is implied in the Constitution. There is something called a unenumerated right. Unenumerated means not written down, okay, not listed, but they just kind of read it into the Constitution, okay, which is basically the judges were using their flexibility that is given to them, okay. So that's basically the idea. So you have some idea now about judicial precedent, okay, and it's very important in the Indian system, okay. Now, just briefly here explaining what this statement is, that most modern common law systems are actually what we can call mixed systems, okay. Now let me explain what I mean by mixed. Now if you look at the pure common law system, it originates from England, okay. Now in England, when it was starting out, when this common law system was starting out, which is when you remember William the Conqueror? Have you guys heard of William the Conqueror? The invasion of Normandy from he actually is a Norman king who invaded England, okay, in 1066 AD. Okay, so around 1100s or so, William the Conqueror and the subsequent kings, they started a system where the judges would start. There was no codified law in England at that time, so they would have a bench of judges who would be going around the country, okay, traveling around the country and giving decisions on various cases. Okay, so this is how this common law system began, because at that time there was no codified law. Like here we have the Contract Act, the Indian Penal Code all written down, okay, insolvency, bankruptcy code, etc. We didn't have all that stuff written down in England at that time. So it was only what the judges were deciding as they were going around the country. Okay, so now that's why judicial precedent became very important, because you did not have any law that was written down. So the only way you could decide the case is, and you wanted to be consistent, so you had to basically follow the way the judges had decided in earlier similar cases. Okay, so that's all there was. There was a bunch of judges going around the country, okay, riding circuit as they called it, and they were riding around the country and they were looking at all the disputes, and so they would go and gather in a particular place in the town square or somewhere, and all the disputes would be brought to them and they would decide those disputes, and then they would move on to another place. Okay, so all that you had was essentially the decisions of the judges on those particular cases. Okay, and slowly those decisions started to get written down. Okay, initially, so basically whatever they were deciding, whatever judgment they gave, like this guy has stolen a horse, so let him be given 35 strokes of the cane or something like that. Okay, so you give a particular punishment. Okay, and then essentially obviously consistency becomes a requirement almost everywhere. So as those decisions started to get written down, the future judges started to follow the decisions of the previous judges, okay, essentially for the sake of being consistent. So that's where this is what was called the common law. So when we say common law jurisdictions today, the pure form of common law essentially has no written down laws, no Contract Act or Property Transfer of Property Act or this, that, Registration Act, nothing is there. Only all you have to go by are the previous decisions of judges on similar matters. Okay, and these decisions started to get written down and they started to keep a record of those judgments. Okay, so that is the pure form of the common law system. Okay, so this is why I say that most of the modern countries where we say that there is a common law jurisdiction, like we say Australia, New Zealand, Canada, US, India, these are all common law countries, but technically they are not like pure common law jurisdictions in the sense that we don't have any codified laws. Okay, so we still follow, it's a common law, these are all common law jurisdictions, because in all of these countries, if you're arguing a case, you can use judicial precedents to put pressure on the judge to rule in your favor. That's why these are all common law, these are all called common law countries. But they're also kind of technically, they're now mixed jurisdictions, because in all these countries, you also have written statutes which have been written down by the legislature. Okay, remember, it's because earlier in the pure form of the common law system in England, the legislature was not really playing any role, because that time there was no legislature, because the king was the legislature. Okay, so the king was basically in charge of everything. Okay, so the king used to send out his group of his team of judges to go around the country instead of everything coming to the king and the king having to decide. So the king would designate a bunch of people, then you be a judge and you go travel around the country, so that there's one consistent law. Common law means one common law for the whole of England. Okay, so instead of the king deciding everything, he had basically delegated this power to decide to all the judges, and they would go around, and that was the pure common law system, where there is no written down law, and all you have is the judgments of these judges on previous cases. Okay, that's the pure form of the law, because that time there was no legislature. So now as this modern form of government developed, where you have the three branches of government, where the legislature has an explicit duty to make laws. Okay, they have an explicit duty to make laws. All right. So if you go back here to the legislature now has an explicit duty to make laws. So in most of these countries, Australia, New Zealand, Canada, India, you have both. You have the rule of judicial precedent still remains, because we come from a common law tradition. So we have maintained that rule. Okay. But we also have now a legislature, so the legislature will come out with various acts, okay, like Hindu Marriage Act, etc. So there now those acts, so when there is a decision to be made about a Hindu marriage, okay, whether a person is entitled to a divorce and things like that, that will be decided according to the law laid down by the legislature. Okay, but it will be mixed. It will be also the law laid down by the legislature, but also how the court has ruled on a similar matter in the past. So both judicial precedents will be used as well as the written down law will be used, what we call the codified law. Okay, are you guys following? This is kind of abstract historical matter, but are you following, or is everybody blanking out? Drishti, you're following? Okay, so is this more or less clear what we are discussing? Okay, just to get some of these historical things in perspective and understand how our system works. So it's still so that's why I'm calling it a mixed system. It's not a pure common law system, because that would mean that there is no law made by the legislature. Okay, but it's a kind of a mixed system, although we call it a common law system, we don't call it a mixed system. Okay, but that's why I said that these are actually now kind of mixed systems. All right, yeah. So there is a lot of codified law. Okay, so that's why I said here, any given case decided by reference to both codified law and judicial precedent in a common law jurisdiction. Okay, right. Codified law includes amendments. Amendments apply. Okay, you understand the difference between prospective and retrospective? Okay, what is prospective? Which is forward looking and which is backward looking?
So retrospective is backward looking.
Yeah, so retrospective is backward looking and prospective means forward looking. Okay, so some of the amendments can be actually retrospective also. Like for instance, when you've heard of the famous Vodafone case, where the big tax case, okay, so so huge amount of money involved, okay, which is still going on. Actually, the dispute is still going on. That is a case that the government of India actually lost. Okay, the Revenue Department lost in 2012 in the Supreme Court. But after that, there was an amendment through the Finance Act of 2012. There were some amendments made to the Income Tax Act, which essentially retrospectively amended the income tax laws in such a way that it basically completely nullified the victory of Vodafone in the Supreme Court. So whatever the Supreme Court had ruled, whatever they had said in favor of of Vodafone, the government went back and rewrote. The whole Finance Act of 2012 is largely based on the Vodafone judgment. So they took whatever the Supreme Court said and essentially they said no. They've nullified all this. Okay, which happens in a lot of cases in India, which is very unfortunate because actually it undermines. In the short term, it looks like the government has gained the victory, but actually it's bad for the system because it creates uncertainty among international investors. We need a lot of investors to come in, pump money into the country. So it's not a good practice.
But so that was essential for the country.
No, I don't think it was essential.
There were certain loopholes that were taken advantage of, which shouldn't have been.
No. It is not. It was a formalist judgment. It was not a loophole as such. It was a formal. You can read the judgment. There's a huge judgment. There's a pretty long judgment. You can read the judgment. That is what many people have said. But the point is, it doesn't matter because you have a system. So if the Supreme Court rules, we have already put the Supreme Court as the highest court in the land. Okay. So this is what Narayan Murthy also said, that once the Supreme Court has ruled in a particular manner, we should accept that, whatever they have said. And it's not a nonsensical ruling. It has a lot of logic. It's a formalist ruling. Their ruling is a formalist ruling. Okay. When you see later on, we look some parts in company law, you'll see the same principle being applied. It's a formalist ruling. It's a perfectly reasonable ruling. But the more important consideration is whatever it is, like some Supreme Court in certain cases has ruled in ways which many people did not like. Okay, Shabano case is one example. Okay, where large parts of the Muslim community did not like the ruling. But the point is that we have given the Supreme Court the position of the highest court in the land. Now, once you've given them the position, then you should not undermine their authority. Once they've given a decision, you should accept that, because then if you go back and amend the law in such a way that you make a mockery, it makes a mockery of the Supreme Court decision, which means essentially nobody can win a big tax case against the government. That's what it means. Because if the amount is sufficiently big, then the government will always go back and change the law retrospectively to make sure that the judgment is nullified. Because right now, even today, the government is pressing Vodafone for that amount. Okay? Which technically I would say they are not entitled to, because the Supreme Court has already ruled that the government is not entitled to that amount. So then you're undermining your own system for the sake of short-term gains. So even that amount that they have levied, if as the Supreme Court said, that is not that's not a valid levy. So what are you actually claiming? I mean, on what basis are you claiming? So there are a lot of problems, and this creates a very bad impression among international investors that, if the government can arbitrarily change the law, because we have to be seen as a nation of laws, that there is a certain predictability and there is a legal system. That is one of the reasons why many investors prefer India over China. because India is seen as a more transparent country, more of a rule of law country, where the government many times loses cases in the Supreme Court. Can you imagine Chinese government losing a case in a Chinese Supreme Court? It will never happen. Okay, so those judges will no longer be alive if they rule against the government. So that is one of the reasons why India is favored to China by many investors. So we have to maintain that. We are now actually we are a Western style liberal democracy. That is how we have fashioned the country, which is a perfectly fine way to go. It doesn't mean that we are giving up our traditions and culture. Everything is perfectly alive. You can see that. All our tradition of music and dance, literature, everything is perfectly alive. And we have made a nice transition into a Western style liberal democracy, which is, and then we have to use that system for our own economic development. So this is not a good thing. This is a short-term benefit, but eventually it will scare away foreign investors, okay, if we do this. Okay, guys, let's, so this clear codified law amendments, some are retrospective, some are prospective, okay? All right. Now, this is a hierarchy of courts. You can just listen to, this is just I've just given you a presentation. I'm not going to go through this because it's kind of mechanical. This is available on the internet. You can just read it for yourself just to get an idea. Because it's kind of mechanical. Okay, district court, high court. Point is that, you know what a hierarchy is? It's a structure, some kind of hierarchy. You have a hierarchy in the army, you have a major general, all this kind of thing, then lower and you have corporal and all these people. So hierarchy is like kind of a kind of order, okay, an ordered listing. So you have a hierarchy of courts, obviously district court, high court, okay, yeah, top to bottom kind of listing, and then you have the Supreme Court on top. Now, this hierarchy of courts is also connected to the idea, now we're going to study the idea of judicial precedent in greater detail, okay. Now, this is a Latin term, stare decisis, which is another way of referring to the doctrine of judicial precedent, okay. So remember, that whole thing at the end of the day is all about consistency, okay. So judicial precedent, it's called stare decisis, essentially means that, whatever has been decided, let it stand. That is basically the idea, the loose translation of this Latin expression, stare decisis. So that is essentially the doctrine of judicial precedent. So the idea there is that because we put a very high value on consistency, so we want that the judicial system should function in such a way that on a certain set of facts, if a previous judge has given a particular type of ruling, later on when the same set of facts happens, okay, transpires, the next judge should also rule in the same way, okay, as far as possible, okay. It's not an ironclad rule. There are some exceptions where you can, if you feel that the earlier ruling was very wrong or something like that. But by and large, we try to follow this system. By default, we try to follow the system. So a judge will clearly say that, you'll see in many of your judgments, which you study, that the judge will say, okay, this is the problem before me. Well, this is not a very difficult decision to make, because there is already a precedent of the Supreme Court on this particular issue. So I will just mechanically apply that precedent and solve this case. Okay, it will be just decided in the same way. Okay, so that is what stare decisis is. And it's all about consistency, okay. And once again, this ties into the role of a legal system. This is consistent with the view where you see the legal system, you can think about many ways. I mean, like again, this connects to formalism and realism, etc. But one of the views of the legal system and the role of the legal system is that it is supposed to foster an environment of certainty and stability, okay. Because at the end of the day, if you look at any country, economics becomes everything. If you don't have economic development, at the end of the day, you have nothing. Okay, so therefore, to foster economic development, you need to produce an environment of stability and certainty for businesses. Okay, at least on the tax laws and other regulations and stuff like that, so that they are able to make long-term plans. Okay, economic uncertainty is always there, but at least on the regulatory side, on the tax side, the government should provide stability and certainty, so businesses can plan long-term. So that's why this is one of the reasons why stare decisis becomes important. Because it is also consistent, it is also in line with the idea of consistency, stability and predictability. Are you able to see that connection? That if you have a rule like judicial precedent or stare decisis, and you are forcing judges to decide future cases in the same way that previous similar cases were decided, that is fostering consistency. Can you see that? It is conducive to consistency in rulings, okay? So that's why it is basically tying in with the larger vision of the role of the legal system being to create a stable and predictable kind of environment so that businesses can prosper and even people can go about their lives in the same way. Okay, like if you have a rule saying, okay, you have the law on the book saying under 497 IPC, adultery is a crime. So anybody who is contemplating doing something like that, he would actually look at the law and he can guide his conduct in the right way. He can say that, okay, I should not do this because I might be punished. Okay, so this is how, so it's not just businesses, but also people can plan their conduct, okay, by looking at the legal system and seeing what the law says, what you should and should not do. Okay, so so this is stuff, general stuff here. Okay, now some terms on stare decisis which we are going to study, okay, which is vertical versus horizontal stare decisis. Okay, if you see, you can see this vertical stare decisis, both are connected to the hierarchy of courts. So in India we have the Supreme Court on top, and then we have all the high courts in all the different states. Okay, so when you have vertical stare decisis, you're talking about higher court, a lower court following the precedents set by the higher court. Okay, so any kind of situation where a district court is following the precedent set, let's say a district court in West Bengal is following a decision earlier laid down by the Calcutta High Court. Okay, so that will be a case of vertical stare decisis. Is this clear? Because it is related to the hierarchy of courts. If you go down vertically, that means you're going from Supreme Court down to the High Court, down to the District Court. People are getting restless. Let's check the time. Okay. Once again, alarm is not working. What is happening? Rooster has failed us. Huh? Volume. Anyway, you guys can go now. I'll check what is happening here. What is all of your minds? Sorry? No, I think next time what I'll do is I'll ask somebody to put an alarm on their phone. Okay, good. So I'll appoint a timekeeper. But you should not set the alarm earlier. Like 10:45. Okay, guys.